Hello class and welcome to the week 4 lecture for Introduction to Law. This week we will be discussing torts, which is chapter 9 of your text. A tort is a civil action that arises when a party infringes on the rights of another person when there is no permission or agreement to do so and causes harm as a result of that infringement. This is one of the two major types of civil actions, the other being contract law. It distinguishes a tort from a contract cause of action is that in tort law, the party's pre-existing relationship is not as important as it is in contract law. This is a very old area of law, arising as it did in medieval England. It has seen a lot of evolution over the years, and you should read your textbook to familiarize yourself with the ways that tort law has evolved over the past millennia. Moving on, I'd like to delve deeper into the field of torts with an examination of the tort of negligence, perhaps the most significant tort. As you can see, this tort is composed of 4 elements. An element is a factor that the plaintiff must show by a preponderance of the evidence in order to recover. All elements must be proven to be true by a preponderance of the evidence in order for the plaintiff to recover. Thus, in order to recover for the negligent tort, the plaintiff must show that the defendant owed her a duty, that the defendant breached this duty, and that the breach of that duty caused harm to the plaintiff. And these 4 elements, said simply, are then duty, breach, causation, and harm. It will be easier to visualize these elements if we can start with an illustrative example. And let's go to the famous McDonald's coffee case, where a woman sued McDonald's because when she spilled the McDonald's coffee in her lap, it caused third-degree burns to her lap. In that case, first the woman would have had to start by showing that McDonald's owed her a duty. Simply put, McDonald's owes a duty to those that would be foreseeably harmed by negligent conduct on its behalf. So in this case, it is clear to see that if McDonald's does not prepare its food correctly, that people could be foreseeably harmed by that negligent preparation. This ties into the next element, breach of that duty. This would ask a jury or a judge sitting as the trier of fact to determine whether McDonald's acted reasonably when it prepared its coffee. In this case, the old lady successfully convinced the jury that McDonald's breached its duty by preparing its coffee at an unsafe temperature. The next element that the woman would have had to show is that this failure to brew coffee at a reasonable temperature caused her harms. One important thing here is that it would have to be shown that it both caused in fact her harm and that it was a proximate cause, which means that it led reasonably and directly to her injuries, thus that it's fair to say that McDonald's caused her injuries through its negligence. Finally, the woman's injuries, that is her medical bills, any lost wages, or perhaps, in some cases, emotional distress that she incurred through these physical injuries, would constitute her harm. And this would have been the easiest element to prove, likely. Realistically, the only difficult element to prove in this case, and where the fighting took place, is over whether McDonald's acted as a reasonable restaurant when it prepared its coffee at the temperature that it did. And I'm sure that many of you have an opinion on this case. Moving on, I'd like to discuss some of the terms involved in tort law with more detail. Reasonable conduct is the first term you should be aware of. This requires the actor to evaluate the surroundings, all benefits, and all risks, and to respond in the most careful manner. This measurement of the reasonableness of the alleged liable person does not usually take into account the mental state of the actor. It does, however, take into account the age and physical conditions over which the actor has no control. Foreseeability is determined by a finding of whether the risk of harm was known by the actor by constructive knowledge, that is, what the actor knew or by reasonable examination of the situation should have known. Proximate cause refers to the doctrine that requires injuries to occur as a consequence of the breach of the duty by the actor, both as a matter of fact and as a matter of law. So when discussing causation, the first causation that has to be proven is whether the negligence was an actual cause of the plaintiff's harm. So in the case of a situation where I'm walking clumsily and I slip and I fall into another person, it's easy to see that but for my walking clumsily, the other party wouldn't have been hurt, thus satisfying that prong of the causation inquiry. Proximate cause is concerned with whether it's fair to hold the defendant liable for the plaintiff's injuries. So the example of the person walking clumsily running into the plaintiff, thereby causing the plaintiff harm, we can see that both cause and fact and proximate cause exist. Cause and fact exist because we can say that the defendant's negligence was a substantial factor in the plaintiff's harm, or in some jurisdictions that but for the defendant's negligent action, the plaintiff would not have suffered harm. Proximate cause because there's a direct link between the negligence of walking clumsily and the plaintiff's injuries. However, in cases where the plaintiff's harm and the defendant's conduct is very attenuated, the judge may use the doctrine of proximate cause to cut off liability. It's hard to even think of examples of situations where proximate cause will cut off liability, but perhaps one example might be if a defendant is driving negligently down the road and as a result the police send a helicopter up in order to track the defendant, and then as the helicopter is following the defendant, a flock of birds runs into the helicopter, which causes the helicopter to malfunction, which causes then the pilot to crash, and then the plaintiff or helicopter pilot in this case sustains injuries. We can see in that case that there's a duty, that is, the defendant owes a duty to drive in a manner that will not foreseeably cause injury to others, that we can see that there is a breach of that duty and that the defendant in this case was not following the reasonable standard of care for a driver. We can see that there was cause and fact in this case, that but for the defendant's failure to exercise the reasonable standard of care, that is, driving safely, that the plaintiff in this case, the pilot, would not have sustained harm, which is also the fourth element, which is also proven. However, we may nonetheless feel that it's unfair to say that the defendant is really a cause of the plaintiff's injuries, because in this case, a whole lot of coincidences had to happen that had little to nothing to do with the defendant's negligent conduct in order for the plaintiff to sustain harm. And in that case, the judge may opt to use the doctrine of proximate cause to allow the defendant to get off the hook for this one injury. Moving on, I'd like to discuss the torts of the negligence tort in more detail now that we have defined some critical terms. First, you need to be aware of the concept of duty. And there are two schools of thoughts that have developed the area the range of duty should include. This refers to either the zone of danger, which refers to the area that the defendant should reasonably expect or foresee his or actions to affect, or the world at large approach, which takes into account a much wider range, and it requires the defendant to foresee more remote possibilities of harm to persons not in the immediate area and of injuries not as readily foreseeable to occur from his or her conduct. Next, we need to discuss the standard of care. And ordinary or reasonable care is expected of defendants and indeed all people in most cases. And that test is whether the defendant, under all the circumstances, exercised ordinary and reasonable care. This under all the circumstances is very important language. For example, somebody who is driving and suffers a heart attack is not expected to exercise the same degree of care that somebody who has no physical impairment who is driving would. And other factors that need to be considered are the underlying reason or necessity of the defendant's conduct. That is, was the defendant acting in a way that had great social value, such as by saving a life? the surrounding physical environment, any activities that were taking place, and the types or limitations of people in the area. Should be noted that this standard can be adjusted up or down. For example, children, until they reach the age of 18, are judged under the reasonable care expected of somebody that is the age of that child. So if a 6-year-old is riding a bike and runs into a person causing an injury, they would be held to the standard of care of the reasonable 6-year-old, which will be a very difficult standard for the plaintiff to prove in that case. On the other hand, certain people may be expected to provide a greater than ordinary standard of care where they have a particular expertise. For example, a race car driver may be held to a greater than ordinary standard of care when operating a vehicle due to their particular expertise. And a person's physical condition may impact the standard of care that they owed. For example, a blind person may be held to the standard of care of a reasonable blind person. Moving on, the next element to discuss in a little more detail is causation. I've already covered much of this material with my discussion of proximate versus cause and fact, but just to reiterate, cause and fact is asking whether, but for the defendant's conduct, the plaintiff would not have suffered an injury in the but-for test. In addition, many jurisdictions use a substantial factor test, which is basically asking the question, is the defendant's conduct a substantial factor in the plaintiff's injury? Proximate cause, as discussed earlier, is whether or not it is legally fair to hold the defendant liable for the plaintiff's injuries. And please refer back to the example of the helicopter pilot for how that doctrine may be applied in a specific case. Finally, the last element to discuss is damage, and this is whether a compensable injury was suffered. Some damages are not recoverable, however, many are. And the type of injuries that are compensable include monetary, which includes things such as medical bill or lost wages, physical injuries, which is the lost use of limbs, mental anguish or emotional distress. It's important to note that in most cases, mental anguish or emotional distress is not compensable unless there is a physical injury tied to it. And these are known as pain and suffering damages or non-economic damages. The last doctrine I want to talk to you in connection with negligence is res ipsa loquitur, which literally translates to the thing speaks for itself. And this doctrine has been applied for many years in cases of negligence involving special circumstances. A plaintiff may claim the doctrine to ease the burden of proof in case of negligence only wherein he or she can prove that the occurrence was of a type that would not happen without negligence, the instrument producing the injury during the occurrence was exclusively in control of the defendant, and the plaintiff did not contribute to the injury. Many beginners to the law have an impulse to apply this doctrine broader than it actually can be applied. These elements are adhered to fairly strictly. One classic example of this is there is a case where a person was standing outside of a window and a barrel fell out of the window, crushing the plaintiff. In this case, the plaintiff would not be able to recover unless the doctrine of res ipsa applies, because without any witnesses, the plaintiff would not even know who to call to prove that negligence existed. However, res ipsa will allow him to satisfy the burden in that case because ordinarily barrels do not fall out of windows without negligence. The instrument was exclusively in control of the business as it was their barrel, and the plaintiff did not contribute the injury because they were doing nothing negligent. They were merely standing outside of a window, which is not rising to the level of contributing to their own injury. And with that discussion, it's time to move on to other torts. And to conclude our discussion of torts, we will discuss two more areas. The first is strict liability. This is a narrow area of tort law, but it is indeed growing fast. Strict liability was developed for cases of persons who obtained some personal or financial benefit from an activity that could not be made safe and from which the innocent public cannot protect itself. Fault, carelessness, or intent is not an issue in actions for strict liability because no matter how carefully an activity might be conducted or an animal might be guarded, it is a near certainty that if the danger escapes into a public arena, innocent bystanders will be harmed. It is further reasoned that the persons in control of the activity or animal benefit from it, and that it is only reasonable that they should bear the cost of harm. This is known as strict liability for ultra-hazardous activities or for wild animal attacks. For ultra-hazardous activities, it might be useful to consider the example of somebody who is blowing up dynamite on their land frequently. If you are blowing up dynamite in an area in which there are people around, even if you are exercising great care, and in fact the greatest possible care, it is the case that perhaps somebody may be injured. And without this doctrine, that injured party ordinarily would not be able to recover. This is because the only duty of care in a negligence suit that would be owed by the defendant is that of a reasonable person using dynamite for an economically remunerative activity. Strict liability is an acknowledgement that in these cases where we can't really get that risk of harm to a level that prevents all harm, that it's just better that we say that the defendant is going to be liable in that case, regardless of the efforts they take to prevent the harm from happening. More recently, strict liability, though, has been expanded to include product liability, and this is used against manufacturers of products. You can see how that would expand in this way because consumers, or the users of products, don't have a real means of knowing how the product was designed and what aspects of it could cause injury. One famous case involving this dealt with Coca-Cola. It was the case that certain Cokes would just explode, the bottle would, due to a manufacturing defect. And in these cases, it couldn't really be said that Coca-Cola was being negligent in bottling their product because this only happened with very few bottles. Nonetheless, because the plaintiff in such a case really isn't in any position to defend themselves from harm other than avoiding all products that might conceivably cause them harm, strict liability for products was created. The next major category of torts is the torts in which the primary element is intent. This is an action where the defendant has manifested an intent to bring about a particular result, and as a consequence, the plaintiff was injured. It must be shown that the defendant acted voluntarily, even with the knowledge that the act would almost certainly bring about the injury. It must only be shown that the defendant knew, or should have known, with substantial certainty, that his action would bring about the injury. It does not necessarily need to be shown that there was an intent to actually produce the injury. A major distinction between gross negligence and intentional tort is that in intentional tort, mere knowledge and appreciation of danger are insufficient. There must be evidence of voluntary conduct in light of the knowledge and appreciation of the danger. In addition, the risk of harm must be a near certainty rather than a likelihood. And there are several types of intentional torts that provide a basis of liability. There are too many of them, in fact, to discuss all of them in sufficient detail, so please refer to Table 9.1 in your book, which provides a rather good summary of the various intentional torts and the elements that must be proven in order for a defendant to recover. We can discuss a couple here just to show how a plaintiff would go about showing these elements in order to recover. Intentional torts are among the oldest of torts, and two of the oldest torts in this old category of torts include assault and battery. The elements of assault are that the actor engaged in physical conduct that may or may not have been accompanied by words and place the plaintiff in an apprehension of immediate and harmful contact. By definition, the tort of assault involves no physical conduct, only the threat of such conduct. It's important to note with the assault protection as this is actually quite a limited cause of action. The classic example of this might be if somebody points a gun at you and says, "I'm going to kill you." Somebody may be able to sue for assault, even if the person doesn't pull the trigger, because in that case, the plaintiff would be able to show that they were under the threat of immediate physical harm and it produced fear. And what is compensable in this case, because it isn't compensating somebody for actual physical harm shown, is this apprehension of harm, this fear that you are going to suffer some imminent physical harm. The next tort is battery, which includes all unpermitted physical contact that results in harm. Battery encompasses physical attacks, medical treatment without consent, and every other conceivable act that results in physical conduct between two parties as long as there is intent to make physical contact, there is no consent to such contact, the contact occurs to the person or to anything that is closely attached that is considered part of the person, and the contact results in injury to the person. So here the intent that must be shown is that the defendant knew or had a substantial certainty that their action would lead to an unwanted touching on the body or something closely attached to the body of the plaintiff. The injury in this case is not necessarily medical harm. It can be harm to dignity too. For example, if somebody spits on another individual, even though there might not be any medical damage and even emotional damage may be fleeting and may just manifest as anger, nonetheless, the plaintiff may have a cause of action for battery as they would be able to show that they didn't consent to the spit, that the defendant intended to make physical contact with either their clothes or their person, and the injury in this case would be an injury to dignity and rage suffered. The third tort that I want to talk to you in connection with intentional torts, and the last that we will discuss in connection with this, is false imprisonment. This is where a party creates boundaries for another party with the intent that the other party be confined within those boundaries. It requires also that the second party is aware of the confinement, does not consent to it, and perceives no reasonable means of escape. False imprisonment has been the basis of lawsuits ranging from false arrests by law enforcement officers to kidnapping and even unwarranted detention in stores by store security and personnel. The intent element here is that the defendant must intend to confine or make another person believe that there is no reasonable escape. And with that discussion of intentional torts, I want to discuss one other doctrine briefly, and that is the doctrine of respondeat superior. Respondeat superior is an acknowledgement or doctrine that arises out of the fact that employees work at the direction of the employer, and that the employee, therefore, is subject to the ultimate supervision of the employer. Therefore, employers can be held liable for the torts of employees when they occur in the course of business. And this is a very important doctrine, as any employee may lead to liability for the employer under this doctrine. And with that, that concludes our discussion for Chapter 9 of the text in our Week 4 lecture, and I'll see you next week.